Yes, Mr. Morane, you referred us to paragraph 101 of
That,
882 Matondo's document.
that is so.
Yes.
That is so. Now, according to Justice Madondo in this paragraph, there's no genuine dispute as to the succession of Prince Misuzulu, as he is, in terms of the customary law and customs, the rightful heir to the throne. No one has disputed the correctness of the customary law and customs by which the name of Prince Misuzulu was raised and endorsed by the royal family. The applicant prince, neither in their founding affidavit nor in their supplementary and replying affidavits have made any assertion that the appointment of Prince Misuzulu was not in accordance with Zulu customary law and traditions. The letter that Princess Thembi Ndlovu addressed to the President, stating that there was a disagreement in the Zulu royal family as to who should succeed to the throne between Prince Misuzulu and Prince Simagade, did not comply with the provisions of Section 8, subsection 4 of the Leadership Act. The President should act when there is evidence or an allegation that the identification of a person as a king or queen was not done in accordance with customary law and customs. No such evidence or allegation has been brought to the notice of the President in this regard. The letter of Princess Thembi Ndlovu lacked necessary allegation that Prince Misuzulu, who was identified by the royal family, had not been identified in accordance with Zulu customary law and traditions, and that Prince Simagade has a better right or entitlement to succeed to the throne. More so, it is common cause that Prince Simagade declined the nomination. As a result, he is not a contender. Even if he purported to accept the nomination, he could not have legitimately been identified, as he does not qualify in terms of Zulu customary law and customs. Prince Simagade's purported identification was accordingly doomed. The applicant has therefore failed to make out a case that there is a dispute about the successor to the throne on the basis of which the President or the Premier may investigate or refer the matter back to the Zulu royal family for consideration and resolution. And this is what the President relied upon. Now,
But, well, the statement that there is no genuine dispute as to the succession, is that what is required in terms of Section 8.4? Because 8.4 refers to an evidence allegation. So we agree that we are not in the realm of Section 59.
Yes.
We are at Section 8.4, allegation.
yes.
And my question to you was, what Princess Thembi raised in her letter that she addressed to the President in June 2021?
Yes.
Is it sufficient to form a basis for the conclusion that there is an allegation that the identification was not done in accordance with customary law and custom? That's my question to you.
Yes, we submit not. And Justice Zondi, we are actually relying on the judgment of Justice Madondo with regard to that. And we are also relying on a decision of the Constitutional Court. It's the case of Chief Abetendi Rachibumo Rambuda and others. This is Chibumo Royal Family and others. This is Chibumo Royal Family and others at 2024 ZACC 15, which held that the Premier in that matter has to satisfy himself that the evidence or an allegation of non-compliance with customary law in the identification of the person before was not frivolously advanced, before referring the dispute to the relevant bodies in terms of the Limpopo Traditional Leadership Act, which we submit echoes the act with which we are dealing here.
But that act doesn't, the wording of that act doesn't say he may, the Premier may, as opposed to must. I think that it does make a huge difference, the use of must and may. But with respect, Justice Zondi, it doesn't alter the principle that it should not be a frivolous allegation. It should be a bona fide allegation, and it should also refer to the identification in terms of customary law. To that extent, we submit that case is authority in this case also. So let me see if I understand your submission. Your submission is that Princess Kendi's letter in which she catalogued a number of irregularities. Those allegations were frivolous, to use a language. I'm not sure. If my understanding of your submission is correct.
Well, we say that they were not directed at the question as to whether the identification was in terms of custom and customary law. That's the critical and crucial aspect of it. I mean, a person can conjure up a dispute based on the fact that the person identified as king to be does not fit the bill in terms of let's say morality or some other factor which is not aligned to customary law. That is the real crucial issue. Yes.
But isn't one of the crucial issues is whether it should be King Zulu because he's the firstborn son of the late king, or whether this Ufagwe Siswen because he's the firstborn son out of wedlock, so to say.
Well, Justice Collins, it will be recalled that that issue of Ufagwe Esiswini was abandoned.
Has it been abandoned?
Yes.
Well, I think that Mr. Moran is still a live issue because he relied on two experts, Professor Mgome Zulu and the Tamba
Mapalala.
Well, there's Professor Mngome Zulu
Yes.
who does say something about this custom of Ufaka Esiswini and Zimande, Temba Zimande. These are the authorities upon which he relies for the contention that as a person was inserted, he is entitled to succeed to the throne.
Well, in my recollection, Justice Zondi and Justice Nichols, I do not believe that Princess Tembi's letter dealt with that particular issue.
I can refer you to page 2487, the custom of Ufake Esiswini.
Volume 13.
2487.
At the bottom of the page of 2487, where the heading is Custom of Ufake Esiswini.
Yes, well, I can put it no higher than that the President was relying on the judgment of Justice Madondo on this issue relating to 8-4. Yeah, and that is paragraph 98 in particular. Yes, paragraph 97 and 98 of Justice Madondo's judgment. Yes. In terms of paragraph 97, the learned judge says, Priest Mangosud Telias, who was in attendance at the meeting, states that before proposing and nominating the name of Prince Misuzulu as the successor to the late Isilo, he explained the criteria which are to be taken into account when identifying a person as successor to the throne. Such criteria are laid down by Zulu customary law and customs. The following criteria are taken into account: whether the ilobolo of that person's mother was contributed wholly or in part by the relevant tribe or nation, and the status of the maternal grandfather of such person. In the present case, it's common cause that the late Queen's ilobolo was paid by the Zulu nation, and that she was born of Eswatini royalty, being a daughter of King Sobhuza II. On the ground of the contribution of her ilobolo by the Zulu nation alone, she precedes other wives in polygamous marriages and becomes a great wife who is expected to bear successor to the throne. The status of her father may now legitimately be interpreted as constituting discrimination on a listed ground, that is birth, and could be in conflict with the equality clause. If it discriminates unfairly against other wives born of commoners, it may fall foul of the provisions of the clause. But the fact that her ilobolo was provided by the Zulu nation cannot be assailed, and it's not a listed ground, but a fact which only serves as a distinguishing feature. It's common cause that there is no contender to the Zulu royal throne. Prince Simagade, who has been mooted as a possible contender, addressed a letter to Prince Mangosuthu dated the 11th May with a request that the letter should be read out Zulu royal family meeting on the 14th of May. In that letter, he disavowed claim to the throne or any intention to claim it. He indicated that he was willing to abide by the decision of the royal family. As a consequence, Prince Misuzulu remains the undisputed successor to the Zulu throne. The two princesses confessedly stated that their application has nothing to do with succession to the throne. It's been argued that Prince Misuzulu has been appointed as successor to the late Isilo by late Queen, who had been nominated and appointed as successor. However, the will of the late Queen is not impeached. The inevitable conclusion is that even if the late Isilo's will is found to be invalid, it would not have any bearing on the succession to the Zulu throne. In addition, the Zulu royal family, which in terms of the Leadership Act and customary law has the prerogative to appoint traditional leadership, assembled on the 14th of May and identified Prince Misuzulu as a successor to the late Isilo. And as I've indicated, I beg your pardon, we are relying on the finding by Justice Madondo, which has not been upset, it's not been taken on review, it's not been appealed against. Now, as far as the remedy is concerned, we submit that remittal was legally inappropriate. We submit that the High Court erred in remitting the matter for an investigation process under Section 8, subsection 4, when it had already held that the identification itself could not be revisited. This is internally inconsistent and contrary to principles of finality in litigation. That contradiction in the High Court's reasoning is stark. It accepted that the identification could not be revisited due to res judicata, but then remitted the matter for further investigation steps to assess the very same identification. I think Justice Nichols raised that issue. That is an internal incoherence that undermines finality, certainty, and the logic of administrative remedies. There was thus no basis to order the remittal, as that was the end of the inquiry, as the list between the parties is no longer alive. Then we refer to the case of Fusion Properties. This is Stellenbosch Municipality, 2010 Zaska 74. This court emphasized that remedies must be tied to a legal entitlement, not a grievance. And in Mulauz versus S, 2015 ZACC, Constitutional Court warned against exceptionalism in overriding res judicata without clear injustice. None arises here, we submit. There is nothing in this record to signal that rare and exceptional circumstances exist, and that there is no alternative effective remedy to justify the relaxation of the res judicata principle. The case has been heard, decided, and relied upon, and finality must prevail. Then we also refer to the case of the Ngwenyama Minerals, 2011, Volume 4, SA 113, Constitutional Court. There the court stressed that remedy must be just and equitable in light of the facts. A remittal based on a non-existent dispute is neither just nor equitable. This is not a case that turns on factual ambiguity. The facts are known, tested in court, and acted upon. President exercises judgment in the face of contestation, not confusion. And to second guess his decision now is to invite uncertainty into a space that requires finality. The remittal relief sought by Prince Magade under 81C1 of PAJA, requiring the President to initiate fresh procedures is tantamount to judicial supervision over a discretionary executive function. The Constitutional Court has consistently held that such remedies are to be used sparingly and only in cases of manifest injustice, and we submit that this is not such a case. Now, our conclusion, we respectfully submit that the recognition decision of the President was lawful, rational, and in full compliance with the Act, that there was no duty to initiate an investigation under Section 8, subsection 4, and the High Court's order setting aside the recognition decision, we submit, should be reversed, and we ask that the appeal be upheld, and that the recognition decision be reinstated, that the review application dismissed with cost, including the cost of 3 counsel. May it please the court, those are submissions.
Cost of 3 counsel.
Three counsel. Yes. Those are submissions.
Well, that case, as far as the cost liability issue is concerned, we did not be guided by Biowatch principle. You are PNPL of the government minister.
Yes.
And the president. So.
Yes. we would submit, Justice Zondi, that not in this case.
Yes.
Here we are dealing basically with contestants who be king. Prince Mbonisi, on the other hand, says that the king should be Prince Buzabazi. Yes, and we submit that this contestation for kingship should not really be brought to the level of the principle of Biowatch. Those are submissions as far as what's concerned.
There's just one aspect that I just want you to address us on. It would seem to me, on reading Madonna AJP's judgment, let's go to paragraph 91. He did not exclude the possibility of attacking the identification once a recognition decision has been taken. Just look at what he says in paragraph 91 and as well as in paragraph 102 of his judgment. One might say he indicated that the door was still open to whoever wishes to challenge the identification, but that could only be done once the recognition decision has been made. I'm not sure if my understanding of those relevant paragraphs are correct.
Yes, Justice Zondi.
Yes.
He does say that, but it does not detract from all the submissions that we have made regarding the finality of his judgment relating to the identification issue.
Right.
Yes. After the identification, of course, anybody can challenge the recognition decision on legally recognizable grounds. But in this case, we say there are none.
Okay. Thank you very much.
That's a copy.
Yes, Mr. Ngoy.
Thank you.
The platform is yours. Your 10 minutes will begin once you are ready. Your 20 minutes.
No, Justice Tony. I don't like to disagree with the judge at the commencement. It's 20 minutes.
Yes, okay.
Deputy President and Honorable Justices
So
of
it's
the Court.
5 to 12 now.
Yes, 5 to 12. Thank you. Thank you, Deputy President. The key findings of the court below are in volume 25 at page 4794. And that's the first key finding at paragraph 56. And that is where the judge refers to section 8.4 and specifically says that that section means that the mere making of an assertion that traditional laws and customs have not been followed is sufficient. The next key finding is at paragraph 60, which is at 4795, the same volume, where he says that the president erred in law in purporting to perform an evaluative function. And that is why he then says that the recognition decision is acceptable to review. And then the last key finding is at 4796, paragraph 61, where at the end of that paragraph he says, it terms thereof, it is notionally possible that should the investigative committee have regard to material which had not been placed before Madondo AJP within the strictures of the application that had served before him, it may either reach a different conclusion or may determine a re-election as a more appropriate course. Such a course, should it be advised, would render any adjudication of the meeting of 14 May 2021 moot. So it's on those reasons that the order, which is at paragraph 66, order number 2, 4798, says that the matter is remitted so that an investigative committee can consider whether or not the identification of my client, His Majesty King Mrs. Zulu, was not done in terms of customary law and customs. Now, what is the problem with that? We submit that there are 5 problems why that finding is incompetent. The first is that the court failed to correctly interpret section 8.4a. The second is that the court failed to properly analyze the evidence. The third is that the judgment, especially the order at paragraph 66.2, contains a glaring internal contradiction. Justice Nichols has already pointed out to the contradiction with paragraph 36, because paragraph 66 undoes paragraph 36. Now, a judge who gives an order that is internally contradictory, the order itself is irrational, it cannot be upheld on appeal. The fourth is that the judge failed to uphold and apply customary law when it was applicable. He actually did a secutus or a secular ruling. And the fifth is that the judge failed to apply the principle of issue estoppel, because he allowed both the issue of identification and recognition to be relitigated before him when it had been finally litigated before Judge Madondo. If I may then start with the first issue, which is the correct interpretation of section 8.4a. We don't have a problem with the judge's articulation of the principles of interpretation, which focus on text, context, and purpose. There he was correct. But we submit that where he went wrong was on the application of those principles. The text, just to remind the court of the relevant section, which is section 8.4a. That text says the following, 8.4a. Where there is evidence or an allegation that the identification of a person as a king or queen, and then it goes on, was not done in terms of customary law and customs, the president, as the case may be, must cause an investigation. Now, we have no difficulty with the second part, that the president is obliged to cause an investigation. The problem is the first part. What is the yardstick to trigger the investigation? So we say the first relevant indicator is that section 8.4a is concerned with customary law. Customary law has its source in the Constitution, particularly at section 211, subsection 1, subsection 2, and subsection 3. Section 211, subsection 1, is the crucial section because it says that the institution, status, and role of traditional leadership, and then it says according to customary law, are recognized subject to the Constitution. So the traditional leadership institution is an institution that must function according to customary law. What that section illustrates, therefore, is that it is the customary law that is the fulcrum or the prism through which traditional leadership exists, and there is an obligation on our courts, you will find that in section 211, subsection 3, to apply customary law where it is applicable. That informs then the nature of the allegation that is referred to in section 8.4 sub a, which would then trigger the obligation on the president to cause an investigation. And that is an allegation that the identification of the king was not done in accordance with customary law. The first baseline of how to look at section 8.4a has already been decided in the Chivumo case that my learned colleague has referred to, which is that as a baseline, the allegation must not be frivolous. But we say that's not enough. In addition to guarding against frivolity, the allegation must be reasonable and bona fide. And the allegation must identify the custom on which it is relied in order to come to the conclusion that it was not complied with. That structure, firstly, of ensuring that there is no frivolity, secondly, of ensuring that the custom is identified and the practice that did not comply with the custom is also identified, ensures two outcomes. Firstly, it prevents abuse, but also secondly, it gives effect to the centrality of customary law to the structure of traditional leadership. And so what this means is that, contrary to the finding of Davis J., it is not the mere assertion that is required by the Act, but it is an assertion that illustrates the nature of the custom and the respects in which it was not fulfilled. But also it is an allegation that is bona fide and reasonably made. And that would therefore require any court interpreting section 8.4a to first identify the content of the custom. The custom is X. And secondly, to set out why it is alleged that the nomination or the identification has not been done in accordance with that custom. We then can look at what happened here, which takes me to my second issue, which is whether or not the court was correct in its evaluation of the evidence that the president had before him allegations that King Zulu was not identified in accordance with customary law. When you look at the judgment itself, it's actually extremely difficult, the judgment of Davis J. It's extremely difficult to work out which document is he relying upon to come to the conclusion that there was an allegation before the president that customary law was not followed. So, because the analysis of the judge, this is in volume 25. So when you look at the analysis of the judge, it starts at 4787, and there is a heading, the recognition decision. He sets out the facts, but where he has to address the question whether or not there was an allegation that custom was not followed, you will find that at paragraph 56, page 4794. Paragraph 57, 58, 59, 60, 61. Thereafter, he asserts a conclusion. So we are left none the wiser about what is the allegation that he is relying upon. We then have to go back and say, well, maybe he is talking about his narration of the facts, but nowhere does he ever identify the allegation that was before the president, and then assess that allegation by reference to the statute. So the best then we can do is going back to the judgment and trying to figure this out at page 4787, paragraph 39, where there is a reference to the letter of the 3rd of June, 2021. And at page 4788, the judgment says, the president further considered in his affidavit that Princess Thembi had contended that King Mrs. Zulu cannot be recognized, appointed, and be coronated in terms of the constitution, customary law, and both the national and provincial legislation. That you'll find at 4788. And then paragraph 40, in his answering affidavit, the president also indicated that according to the premier, it became clear during the process of nominations the royal family was divided on the final decision as to who should be the successor. And then you then, at paragraph 42, there's a reference to the letter of the 9th of March, 2022. That's the letter that comes from Prince Mbonisi's attorneys, Mabaso attorneys. So it seems, therefore, if we are to take a generous view of the judgment, that there are two documents that are said to constitute the evidentiary basis for Section 84A. Unfortunately, the second document, which is the letter from Mabaso attorneys, did not exist at the time of the judgment by Judge Madondo. But the letter from Princess Thembi has been dealt with by Judge Madondo at paragraph 101. And he is clear that that letter does not meet the threshold for a complaint that customary law was not followed in the identification of King Mrs. Zulu. That letter itself is at volume 13, page 2468. So the first answer to the question whether there was an allegation is that it has been dealt with finally by Judge Madondo. But if we look at the letter itself at volume 13, page 2468, so the actual letter signed by the princess doesn't say anything. The letter is 2468 to 2469. It's the attachment that refers to this alleged allegation. But the problem with that letter is that it's actually very difficult to pinpoint an allegation that says that King Mrs. Zulu was not identified in accordance with custom. Nowhere does it specify the process that must be followed under Zulu customary law for the identification of a king. And nowhere does it say the following steps were not fulfilled in the context of the identification of King Misuzulu as a king of the Zulu. The first time, after there's quite a lot of things that are being said in the letter. The complaint about the will, and the complaint about whether or not the late king, King Zwelithini, was correct in identifying Queen Mantombi as regent. But the question that must be answered by Section 8.4a is whether the identification of the reigning monarch of the Zulu, King Misuzulu, was not done in accordance with customary law. The first references we get there is at page 2508 and 2509. But we need to look closely at what is being said. At page 2508, paragraph 10.16, this is what is being said. In a bid to salvage his case, Prince Buthelezi called a meeting scheduled for the 14th of May, purportedly at the behest of the matriarch of the royal family. In terms of the court papers reported on at page 5 of Isolezwe, dated 23 May 2021, Prince Buthelezi is reported to have said, on the 14th of May, the royal family met and unanimously decided that Prince Misuzulu ascend to the throne as the king of the Zulu nation. It is vehemently disputed that this meeting could have salvaged Prince Buthelezi's case, given the fact that this meeting was called under false pretense and it was intended for the ironing out of differences between Prince Buthelezi and Prince Mbonisi and Princess Thembi on the other. And then it goes on about the false pretense. Then it says, but instead throws Prince Mbonisi and Princess Thembi into the deep end by drafting them into the agenda to acknowledge the nomination and ascendance of Prince Misuzulu without their knowledge and consent. Then it talks about the agenda. And then further, it is appropriate to record that princes and princesses born of His Majesty were invited to the meeting under false pretenses. So far, there is no identification of the custom of the Zulu on the succession of the king. And there is no identification of the manner in which that custom was not complied with. Then we look at page 2509. We also get a conclusory statement at paragraph 10.17. Having regard to the aforegoing, it follows that at no stage was Prince Misuzulu identified and or nominated and accepted by the royal family for the purposes of being recognized and appointed as the one to ascend to the throne for the following reasons. They talk about the 7th of May meeting, the 14th of May meeting, and then they say it is vehemently averred that having regard to the preceding paragraphs, Prince Misuzulu cannot be recognized, appointed, and coronated in terms of the Constitution, customary law, and both the national and provincial legislatures. It is vehemently averred that the decision to identify the king rests with the family in terms of the Constitution, customary law, and both the national and provincial legislations. So this is the full extent of what you will get the references to custom. There is no allegation that the identification of King Misuzulu was not done in accordance with customary law. In fact, there is not even an attempt to set out the content of customary law. The president had this letter. He says he had it. In fact, the president addresses this issue at volume 6. And again, it's important to look closely at what he says. At volume 6, page 1020. So at volume 6, 1020, the president responds to this. He never says that this letter constituted an allegation that the identification of King Misuzulu was not done in accordance with customary law. He says in the middle of the paragraph, the upshot of this letter is that it notes that Prince Misuzulu was never identified and or nominated and accepted by the royal family for purposes of being recognized and appointed as the one to ascend to the throne. Now we have to draw a distinction between the role of the royal family, which is a statutory role, and the custom of identifying a king, which is a pure customary practice. The two seem to have been conflated. The insertion of the royal family into the identification is a statutory requirement, which we accept must be fulfilled. But it is not a customary requirement. The custom is clear. It's set out in various paragraphs.
All right, I must warn you that 20 minutes.
Yes, this is, it came at the right time. Yes, it came at the right time.
Under protection.
Yes, yes, thank you, Justice Stone. So, just to close this part, there is a distinction between the statutory requirement that the royal family must be involved. That is all contained in the Poison Act. But the succession in this case is in accordance with custom. What is the custom? The custom is set out in various paragraphs, but most importantly, it is contained in the affidavit of Prince Buthelezi. Now, I am not talking about the unsigned affidavit. I'm talking about the signed affidavit, which was filed in opposition to the interim interdict. That you will find at volume 10. At volume 10, page so the affidavit starts at page 1095. But he then sets out what the custom is. And you will find there the custom is set out at page 1932 and 1933. So he says, before Judge Madondo, I explained what the custom is. And the custom is set out at page 1933. It says, the heir to the throne was thus a matter settled or predetermined by Zulu custom and customary law. It is settled custom that a queen born of royalty takes precedence over any other queen or wife of the king, in this case the late king. It is also settled customary law that the queen of royalty for whom the nation paid lobola is a bearer of the king to ascend to the throne after the death of the reigning king. Paragraph 52. The Zulu nation paid lobola for the late queen, that's Queen Mandom. In terms of the Zulu custom, the payment of lobola by the nation to secure the betrothal of the late queen and the late king served as a guarantee or surety to the Zulu nation that the first son born out of that relationship would be the successor to the throne. Now, I accept that there are Section 9 problems that arise here, but they are irrelevant for this case. This is a case of 3 men. Paragraph 53, the implications of the Zulu nation paying lobola for the bride are far-reaching. It creates an inextricable social pact between the two nations that the first son born of the marriage between the two royals will produce a successor to the throne. The late queen's status as a daughter of another royal family, the king of Eswatini, she was the daughter of King Sobus, was itself a predeterminant that she should bear a successor by Zulu custom, elevated her above all other wives, present and future. The custom is prevalent among and is adhered to by most, if not all, the Nguni nations. It is also embraced by most, if not all, Africans, indigenous nations, and universal recognition for this custom among the Nguni people. Now, this custom has actually never been disputed in this case. Even the allegation about ukufakwa proceeds on the assumption that this is the correct custom. It is an issue of seniority within the custom that is accepted. But even if it was disputed, we were the respondents in the court below. And on Plascon Evans, our version of the custom, supported by Prince Buthelezi, who has been around since 1968, for 50 years, would have been accepted as the correct rendition of custom. Now, of course, it is true that there was this meeting of the 5th of May, but it is dealt with in this affidavit fully. At page 1936, paragraph 115, it is a secret meeting, but it is also irrelevant in terms of the custom. But it is also contradictory, because the one says so-and-so was identified, but the other says they were not identified, but it's dealt with on the papers. What is also dealt with is the question of the composition of the royal family.
Okay. Your first problem in that meeting is that it was secret, and the second one is, I think, it's
Well, there is contradiction about what was discussed.
what was discussed.
Yes, about specifically about the identification, there's contradiction. Yes. But it has no status in customary law, as Prince Buthelezi points out. But it also deals with the question about the composition of the royal family. That you will find at 1923, from paragraph 71, right up to paragraph 88. Now, that's the respondent's version about who comprises the royal family. It also deals with the status of Prince Mangosuthu Buthelezi as a prime minister of the Zulu nation, and therefore entitled to convene meetings, including meetings about succession. So we come back then to where we were. These three questions, the propriety of the meeting of the 14th of May, are dealt with fully in the answering affidavit. The nature of the customary law is dealt with fully. The meeting of the 5th of May 2021 is also dealt with fully in the answering affidavit. We then come back to the President's decision to recognize. Under Section 84A, the President had to recognize unless he had an allegation that the identification was not done in accordance with custom. I've taken the court now through to the actual document. That document says many things, but what you will never find in it is an identification of the custom and the manner in which King Misuzulu's nomination contradicted that custom. Especially since we now know that custom pre-exists the royal family. The royal family is a recent invention by statute, but custom pre-existed. And that is why Prince Buthelezi says there was nothing that the royal family could do if the custom had been complied with. Of course, the candidate needed not to be disqualified under Section 8. The candidate is disqualified, mentally incapable, or any of those disqualification criteria. Then they would not be qualified.
Well, let's go back to that meeting of the 14th of May. The person who called that meeting, Prince Buthelezi,
Yes.
was authorized to do so. He had authority to do so. Because that's one of the allegations on which they rely for the contention that meeting was improperly constituted.
Yes, but even if we...
Sorry. My next question is, do we have an established practice in terms of which the meetings are called within the royal family? Do we have someone who has been identified to say, Prince so-and-so is responsible for calling the meeting which has not been called by Prince so-and-so, we are not going to attend it.
Yes. The affidavit of... let me try and answer this question. To trigger a Section 84A response by the President, it's a narrow inquiry. It is whether the identification was not in accordance with customary law. That's got nothing to do with the composition of the royal family. It's got nothing to do with the calling of the meeting of the royal family. Those are all statutory requirements. The question in custom, if, for instance, they had taken the second-born son and said, well, this is the person.
Well. But that would be the last step of the process. One would imagine that it would be a first step that would culminate in the identification. It doesn't take place in vacuum. Something must be done before the platform is created for it.
But that does not trigger Section 84A, because Section 84A is a specific provision, which is the actual identification that it seeks to impugn. And it seeks to impugn it on a very narrow ground, that it was not done in accordance with custom. So you always have to establish what is the rule of custom that you claim was breached. If you cannot say that in your allegation, and that is why Judge Madondo's paragraph 101 is actually unassailable, because he says it fails to contain the necessary averments that would comply with Section 841, because they can't identify the custom, and therefore they can't identify the breach of that custom. But if we are to broaden the debate into the question of that meeting, who has the right to call the meeting? We know that from the affidavit of Prince Buthelezi himself, he says he has called these meetings for more than 50 years, since he became the Prime Minister of the Zulu nation. That you will see at so where he first addresses 1914 of volume 10, from paragraph 49, that's where he first addresses the attacks on him personally. And then thereafter, he explains at paragraph 55, where the whole thing started of him being involved in the affairs of the kingdom. Paragraph 55.1, in September 1968, when my cousin, King Cyprian Beguzulu Kasolomon, passed away, I made all of the arrangements for his funeral. I had served him for 14 years as a Prime Minister of the Zulu monarch and nation, a position he had appointed into in 1954 during the unveiling of King Shaka's tombstone. In all my years of service to the king, not a word was uttered by anyone suggesting that I was using my position for any kind of gain. There is no payment to this position, and it carries with it a burden of responsibility that few would be willing to bear. Then he goes on to talk about, this seems to be his complaints about the ANC. But they're not particularly relevant. Then at 1923, from 71, I've already referred to that. And then 73, at page 1923, for the reasons I will explain in a moment, I am an expert in Zulu custom and customary laws. I have acquired this expertise through information and history, passed on to me by my forebears in accordance with Zulu oral traditions. 75, he explains his knowledge. 78, that he himself was born of royalty. And then 81, where he talks about his mother, Princess Magogo. And then the composition of the royal family, 84. And then the meetings of the royal family from 89, that he convened those. He was entitled to convene those in terms of his position as the Prime Minister. 93, 94, 95, 96, he attaches the minutes. 100, paragraph 100, and then up to 104. So we submit, therefore, it's clear on the papers that were before the High Court. The person with the authority to call these meetings is Prince Buthelezi. He derives that authority in part now from custom since 1954. He knows who comprises the royal family from his own personal experience. And then that is why he's then entitled from paragraph 105 onwards to say this is how the king was identified. My colleague is pointing me to paragraph 82, so maybe I should have read it out. Paragraph 82, I referred to the paragraph, I didn't read it out. I think that's what is being said. Paragraph 82, 1925, my role as the Prime Minister, Undunankulu, of the Zulu nation, from time immemorial, has always been to convene meetings of the royal family, to discuss matters pertaining to the royal house, royal family, usually on the instruction of the reigning king. And in the absence of any such king, I'm entitled to call such meetings of my own accord as and when the need arises. During my tenure as Prime Minister, there has never been an instance in which a meeting of the royal family has been called by any person other than me, either doing so of my own accord or on the instructions of the reigning king. So if we are to expand the debate and ask whether or not Prince Buthelezi had the locus standi as Prime Minister to convene these meetings, the affidavit is clear and it's backed out by evidence.
Mr. Matobi, the letter that was written by Prince Samakadi,
Yes, well, he didn't.
that was read out at the meeting.
Yes,
He was aware the meeting was taking place and it was about identification.
yes,
He never objected in that letter.
yes. No, he didn't. And there, Justice Alduka, it doesn't really matter whether you read his letter as saying, I am disavowing my claim, or whether you read his letter saying, I'm reserving my position in case I get nominated. The fact of the matter is that he knew that there was a meeting about identification. And it's clear from the agenda that this is a meeting
Now,
about identification.
There were two people who sent apologies,
Yes,
and that was him and Princess Tembi.
Princess Tembi, yes.
But is there anything in the papers that indicates that they were both objecting to a meeting taking place then about the identification of the king? In terms of the customary?
No. Well, this is the whole thing about this custom that when we move from the royal family, into the custom, the content of the custom is clear. The person who must succeed is a person born of royal blood, whose mother, because Justice Madondo actually captures this very powerfully. He says succession follows the status of the mother.
And there's never been a dispute
Never.
about that amongst the parties.
Never.
Now, if you look at Judge Davis's judgment with regard to this point, surely he would have had to deal with the identification as to whether or not it had occurred according to customary.
Yes.
To make the remittal.
Yes.
Because you can't make the remittal on the basis that you're going to have to appoint an investigative committee in
Yes.
terms of Section A4.
Yes.
Again, with regard to identification.
Yes, this is the problem. This is the third of my...
We're going round in circles.
Yes, this is exactly the problem. That's the third of my arguments, that the judgment contains an internal contradiction. Because at paragraph 36, he finds that the issue of identification is a closed matter. At paragraph 66, he says they must go back and do an identification again. So it's an irrational judgment.
Mr. Nkatobi, correct me if I'm wrong, but the impression I get is that your argument is quite a narrow one. Is that Section 8.4, the only trigger to Section 8.4 is if there is been no proper identification, and there is nowhere in the papers anywhere that it is specifically alleged
Yes,
that King Zulu was not properly identified.
in accordance with custom. There are allegations.
In accordance with
Yes,
custom.
there are allegations about the royal family.
Yes. But in accordance with custom. Is that the sort of crux of your argument?
Yes. On the first part, that's the argument that, and that argument, Justice Nichols, you are correct about it. It comes from Judge Madondo, paragraph 101, that if you look at Princess Tembi's complaint, it says many things.
But it doesn't
Yes.
query the
Yes.
identification of King Zulu.
Yes. Nowhere does it.
According to custom.
According to custom, yes. This is a very simple exercise. You identify the custom, and then you identify the gap. What you cannot do, and this is the problem with Judge Davis's judgment, he says, as long as you mention custom in your letter, then you trigger Section 8.4. But that just makes nonsense of the statute.
And you say that the statute is quite narrow.
It's a narrow statute, yes. You have to identify the custom, and you have to identify the gap with that custom, the inconsistency, or the breach of the custom. You don't have to prove it, which is the evidence part, but at least you have to identify it, which is the allegation part.
So if the matter is remitted, I'm just thinking out aloud, if the matter is remitted and the investigative committee is appointed and they have to investigate the identification, so you have to go through contenders.
Yes.
and the contender has to be in terms of settled custom.
Yes. Yes. No,
born
precisely.
of royalty.
Yes, I mean, this is, well, I mean, there's a rule of law problem. You first have to set aside Judge Madondo's judgment in order to do what is in paragraph 66, because he is unequivocal that the identification is in accordance with customary law.
But you know, I understood your heads of argument to be saying res judicata is not viewing it through the lens of the Constitution, which surprised me somewhat because I thought the res judicata would be in support of your client.
Yes, it is in support of my client. I'm not sure which part of my heads, but certainly in the second part of the heads, we firmly rely on in support of the recognition decision on res judicata.
Oh, I see.
Yes. And in support of the identification decision, we say that was done in accordance with custom. Yes. And we say that before the president, there was no allegation that it was not done in accordance with custom. In fact, we rely both on res judicata and issue estoppel. And issue estoppel covers both Prince Mbonisi and Princess Magadi. They were there. They were in that court, either as applicants or as respondents, but they were there. Then the third topic, I've now covered the second topic, which is the analysis. There is a second letter, I've almost forgot about it. There is a second letter, which is the letter of the attorneys of Prince Mbonisi. That you will find
That was the one that was after the judgment.
That was after the judgment. So you'll find that in volume 1. From Mabaso attorneys, yes. Now, those are the only 2 letters referred to in the judgment, that were sent to the president. So that you will find at volume 1, at page 93, yes. Now, it's 3 pages, 4 pages. Its nub is to complain about section 8.1. That is the nub of that letter. And it never identifies the custom. It complains about the composition of the meeting of the 14th of May. But it never says this is the custom and this is why the custom was not followed. And then it threatens litigation, threatens an appeal against Judge Madondo, and then it threatens a review of the president's recognition if the recognition goes through. But the problem is this, you still don't get to the threshold where the custom is identified and the gap is identified. And this is the problem everywhere you go. The issue was always, this meeting of the 14th of May was not properly composed. That was always the issue. But what they missed throughout was they were never able to say, in terms of the customary law of succession to kingship, these are the rules. And you did not meet those rules. So even that second letter simply falls below the threshold. And the logic of Judge Madondo in paragraph 101 equally applies to that letter from the attorneys. So that then takes me to the third point, which is that there is a glaring contradiction in the judgment, and already a lot of water has flown on this topic. You will find this contradiction at volume 25. So we start with paragraph 36, which is at page 4787. Because he says here, I therefore find that the plea of res judicata raised on behalf of the respondents is good, and it is not open for this court to overturn the judgment of Madondo AJP. And then this is what he says, Justice Nichols, which is what would happen if the principal relief, namely the review and the setting aside of the identification decision of 14 May 2021, were to be ordered. So if I order this, I would therefore reopen Judge Madondo's decision. You compare that with what he actually ordered, which is at page 4798, paragraph 2. The matter of the recognition of the ISILO is remitted to the first respondent, who is directed to act in accordance with section 8.4 and 8.5 of the Khoisan Act, to appoint an investigative committee as contemplated in that act, and then it says to conduct an investigation and to provide a report in respect of the allegations that the identification of the second respondent was not done in accordance with customary law and customs. The problem is that he has already closed the question of the identification, but he is also reopening it. So we would therefore submit that given this glaring contradiction, the judgment simply cannot stand. You have to scratch out the second part of the judgment so that it's a judgment that is internally consistent, beginning and end.
But in any event, the outcome of this investigative committee, can it undo Madondo AJ's judgment? Because that, it seems to be what the judge is suggesting at the end of paragraph 61.
Yes. Well, I mean, yes. Well, Justice Zondi,
Jurisprudentially, it can't happen.
yes. In law, it can't, but the judge thinks that it can. And because he says here, it is notionally possible that should the investigative committee have regard to material which had not been placed before Madondo AJP within the structures of the application that had served before him, it may either reach a different conclusion. So he then runs headway into the rule of law. Because now you have bureaucrats overturning judges. And so insofar then as there may still be an issue around this, my colleague, Mr. Morane, has referred the court to paragraph 101 of the judgment of Madondo, AJP, which closed the issue of identification. So we say that the third point is actually straightforward. You simply have to compare the judgment for internal consistency. And it's consequential here. It's not a mere happenstance. It's a consequential thing because the order that he gave is precluded by the finding he makes at paragraph 36. That then takes me to the fourth issue, and that's the issue whether or not there is still a question mark, because the basis of the paragraph 66.2 is that there is still a question mark about the identification of His Majesty King Misuzu in accordance with customary law. That is something that needs to be investigated. But we say, firstly, on what was before the president, there was no allegation that the identification was not in accordance with customary law. I've already made submissions on that issue. But we also say on what was before the judge, there could be no real contest about customary law. This I have addressed already in relation to Prince Mangosuthu Buthelez's affidavit about the content of customary law. But it is also set out in volume 1, page 147. That's in the judgment of Judge Madondo. So if you see what he says about custom, in the middle of paragraph 59, It is the customary law, not common law, which should be strictly applied in resolving a traditional leadership dispute. The king is not appointed, but is determined by birth. Only a mother of a would-be king is appointed to bear an heir. The status of the mother, or the person who intends to ascend to the throne, or is to be appointed king, is a decisive factor. So follow the status of the mother. Now, of course, we know here that what happened is that after the death of the late King Zwelithini, he nominated Queen Mantombi, and Queen Mantombi then nominated the eldest son. But that's not the issue before us. The issue is what is the custom in relation to the actual succession. So here he says the first rule is you follow the status of the mother. And then we also know that that is also supported by Prince Buthelezi. I've already referred to volume 10, page 1896, and up to page 1933. And the rules are clear. A woman of royal blood takes precedence, number one. Number two, a queen of royalty whose lobola is paid by the nation bears the heir. Number three, the Zulu nation paid lobola for Queen Mantombi. Number four, the late king nominated Queen Mantombi as regent. Number five, Queen Mantombi nominated King Misuzulu by custom. This is also supported by King Misuzulu's own affidavit. You will find that at volume 21, page 4183. So at page 4183, volume 21. Now this is the affidavit of my client, King Misuzulu, at paragraph 11.1. So firstly, he denies that Prince Makade is the so-called firstborn son of the late king, or that he was at any time considered to be a descendant in the sense of a blood relation, and thus born into the royal family of a son born from a wife of the king, which is also a queen. But then he sets out what the custom is, 11.2, 11.3, 11.4, 11.5, 11.6. Now, regrettably, he had to attach an unsigned affidavit of Prince Buthelezi for reasons that are known. But it was legally irrelevant because Prince Buthelezi had deposed to an affidavit in this matter before his passing on the same terms that are confirmed by King Misuzulu. And the unsigned affidavit, to the extent that the court wishes to have regard to it, but is largely confirmatory. You'll find that at volume 20, page 3837, the relevant paragraphs. So you'll find that at paragraph 197, 3837, volume 20, where he says, well, no one else was eligible under customary law because this is the custom 198, 199, 200, 201, 202, 203, 204. Then it goes on and on.
Now, the status of a person who has been affiliated to the Great House through the custom of his father as a king. When it comes to issue of succession, can that person overtake, as it were, the biological firstborn? I'm not sure.
Well, according to...
That's a basis upon which Prince Makade is feeling to be entitled to be identified because the custom of
was performed.
was performed, and that customs in a way elevated his status.
Well, there are two answers to that, Deputy President. The first is that the basis for that allegation is Prince Zebulon's book. The authority for it is the book by Prince Zebulon. In other words, setting out what the custom is in relation to ukufagwa and what it does. Now that is dealt with in the answering affidavit, the unsigned answering affidavit. But this is not important because it's an extract from the book itself. That you will find at 3852. And that is referring specifically to Prince Simakade. And there is a Zulu version at the beginning of the page. Okweta ukuba uSimakade abelelwe esigodlweni kwakhangela amankengane ukuthi ingane eyangithanda isencane lena ndaba ezitha. Ikwala noma kunemimoya eshisayo. Lena yenta ukuthi angahlali lo mntana lapha kimi. Bahlale bemlanda bethi hayi akufanele ahlale kimi. Kuyasa sethu umntana useyaqhamuka ngebhasi. Kanti usemncane kakhulu ukuba angazihambela yedwa. Ngagcina ngathi mina ngonyaka utakuhlahleka lo mntana ngoba lokhu ethatha ehanjiswa akayekele umntana ahlale lapho athanda khona. Uma engasathandi lapha kwakhandela amankengane uyakuphinda ahambe futhi nakhona. Imithi yonke ingeyenkosi. Yena lo mntana ongowenkosi nje angahlala noma kuphi. Wathanda ke lo mntana kwangangoba lesikhoke nesikole wate wasiqeda ehlala nami lapha esigodlweni kwakhangela. The English translation comes immediately after that. What makes him Prince Simakade close to the Kwakhangela Mankengane Palace is that he was very close to me from his childhood, even though there was a bad vibe and a feeling that he was not supposed to stay with me. They would fetch him, and the following day we would see him getting off the bus. Even when he was too young to travel alone, I ended up suggesting to the king, that's a reference to Gonyama, that this child should be left alone to stay where he prefers to stay. Otherwise, he was going to wander away and get lost. If he prefers to go away from Kwakhangela, he will be free to leave because the king has many homesteads. So Prince Simakade lived with me at Kwakhangela until he finished school. So the first basis of this allegation of ukufagwa is not supported by the very authority that they refer to. But it is also refuted at the following page, 3853, paragraph 252, right up to 275. And one can imagine this, justices. Ukufagwa, especially at the royal family context, particularly ukufagwa for the purpose of succession to kingship, is a big thing. There is not a shred of evidence, no photo, no picture, nothing of what transpired on the occasion. It's not a one-day event, it's a series of events to signify this elevation. So you have an empty assertion that is not backed up by any evidence. And then you have all of this evidence in the answering affidavit that authoritatively refutes it, because it's a big thing, it's a ceremony, it's an event, it's an occasion. And you find here...
Yeah, sorry. If now the allegation that he was forward is correct. Well, you've already seen.
Just Zulu, can you just argue in Xhosa or Zulu? I think made it easy for all of us, rather than going into the language and
We have to try because I mean it's customary law. We have everything is in accordance with custom.
everything is
So-
language, right?
Assuming that this assertion is correct. Now, if that custom was correctly performed and it had legal consequences as suggested by Prince Simagate, then I found it strange that the Queen, that is late Mantombi
Yes.
Dlamini, would have in her will nominated Prince Misuzu, because I mean, if the custom of Ukufagwa has consequences that the person who has been inserted can overtake the biologically heir, then one would have expected Queen Mantombi to have nominated him in her will.
Well, Justice Zulu, we would have expected the king himself.
Well, the king, maybe he didn't want to create a dispute within the family. He just maybe he wanted to stabilize the situation to say, I'm appointing my wife as a regent for the time being. Then it's for my wife to decide
Yes.
going forward. But I think that the whole purpose there was stability in the family.
Yes. Well, we agree incidentally with that. What is clear that the wish of King Zolete was that Queen Mantombi must make the decision.
Yes.
But if it is correct that Princess Magate got into the royal family through the custom of Ugufago, the purpose for Ugufago and his rendition was so that he could be the first in the line of succession. But that is a ceremony and a custom that would have been performed by the late king. So when the late king identifies the successor, the logic, according to Prince Magate, would have been, I have already decided the success. I did the custom of Ugufago. And that is why I'm nominating Princess Magate. So the fact that the king never did so, the king decided that the decision ought to be made by Queen Mantombi, is itself in conflict with any notion that Ugufago was performed for the purpose of determining succession. But in addition to that, Queen Mantombi would have been part and parcel of the custom of Ugufago. And she herself would have then nominated the person who has been adopted through the custom of Ugufago. But none of those things happened. And that's all in addition to the total lack of facts that are alleged by Prince Simagate. And the fact that the book that they rely upon explains what Prince Zebulon did. He went around interviewing the members of the royal family and interviewed the person directly, Queen Mantombi. How did this child get to this family? And Queen Mantombi explains what happened. And there's no reference there to the custom of Ugufago.
So
Would
are
he
you
not
saying that
have
there was no, sorry, are you saying that there was no Ugufagwa customary rites that took place?
Yes, that is, if you go to page 3, firstly, on what is stated by Queen Mantombi, there was no such a custom. But at page 3853, that is expressly refuted. In fact, it says the custom of Ugufago was never performed.
Would Prince Simakade not have mentioned it in the letter if it was so important?
Well, yes, this is the point made eloquently by Mr. Morane, that if his claim to the kingship was that it was through the adoption by virtue of Ugufago, it would have been uppermost in his claim when he wrote the letter of the 11th of May. But Justice Zondi, at paragraph 259, page 3855, the question you asked me a minute ago, and I realized I didn't answer it. The answer is there. It is unheard of in all circumstances of a child affiliated to a house ever taking precedence over and above the children born of, in this case, the late queen and the late king during the subsistence of their marriage relationship.
But this being the unsigned affidavit
This is the unsigned.
of Prince Buthelezi, to what What weight must we attach to it?
It is supported by King Zulu as a rendition of custom. And this is all much to do about nothing. There is an affidavit by Prince Butelis filed in answer to the interim interdict, which he signed.
But does he deal with Ugufagwa in that affidavit?
No, he doesn't. He doesn't deal with the custom of Ugufagwa. But there's a shorter answer to all of this, that the basis of that allegation is Prince Zebulon's book. Prince Zebulon's book contains a full extract of what Queen Mantombi stated. So we therefore submit that the custom of Ogufagwa is simply not a basis for a claim, a legitimate basis for a claim to succession. In fact, Judge Madondo was clear on this, that there are no other contenders. He had gone through the whole list. He came to the conclusion that there are no other contenders. I have already addressed the issue of the composition of the meeting of the royal family. The Mpepu decision, as correctly identified by Judge Madondo, is distinguishable, and that is where what they did, they took members of the royal council and conflated them with the members of the royal family, which then contaminated the meeting of the royal family. But here, the composition of the royal family is set out in the affidavit by Prince Butelis, the signed affidavit in response to the interim interdict proceedings.
Well, approximately 140 people were in attendance.
Yes.
But, well, there were some that were there for other purposes who were not really family members.
Yes.
And as opposed, well, then there's a meeting of the 5th of May. It was attended by how many people? 14 or
15.
15.
The affidavit says 15. Well, I mean, and then there is also, Justice Son, I'm glad you've raised that point, there is also the meeting of the 29th of September, you know, which is also attended quite significantly by the royal family. And there they debate, what should we do now in the light of all of these issues and the complaints? They are still unanimous, even at that meeting. They were unanimous on the 14th of May, they are unanimous on the 29th of September 2021.
Well, I see it's 1 o'clock now. It's convenient time to take a lunch.
Indeed.
You still have some further submissions to make, or can I allow you to proceed? Or
No, I only have
don't want
one.
to cut you short.
I think I'm probably left with 20 minutes of my
Okay,
allocated.
then we'll come back.
I only have one item. I'll use the remaining time for that.
Okay. We'll come back at 2 o'clock. The court adjourns for lunch until 2 o'clock. Thank you.